Welcome everyone. Thank you for joining us today for today's webinar, Decoding Personal Income Tax 2020 and New Labor Code. My name is Brian and I'm the director of Deloitte Vietnam, and I'm excited to be hosting this section today. The COVID-19 pandemic has been and continue to affect the operation of all organizations across all industry. More than ever, HR management team whose role is to connect employer and employees is facing significant challenges, especially in current context where labor market and legal environment are changing due to the social and economic impacts of COVID-19. For that reason, our webinar today is with the purpose of helping the enterprise as well as workers to be updated and comply with the new regulations and propose strategic plans to get through the crisis. Just a little bit of housekeeping before we get started. Your mic and camera functions will be turned off. If you have any questions during the presentations, please type them in the question box in your Zoom control panel. You can send your question in anytime and we will collect this and address them during our Q&A sections. Slides will be available and you will receive an email with a link to their content. I'm pleased to introduce today our speaker, Ms. Ngoc, Tax Advisory Director of Deloitte Vietnam, who has been more than 10 years of experience in providing global employer services. So now, without further ado, we'll turn the time over to Ms. Ngoc.
Hello everyone. I hope you are very well today. And thank you, Brian, for the great introduction. So allow me to start with the sharing on decoding personal income tax and new labor code. There would be, give me a second. All right, okay. So a little bit about myself. I'm Ngoc. My English name is Jade. I have been working for Global Employer Service for over 14 years, having experience in providing solution, remedial action to many multinational company and reputable local firms, resulting in valuable cost and saving for the client. So I've been working for personal income tax and payroll compliance for many clients across industry, oil and gas, banking, FMCG, financial consulting, and healthcare information technology, and many other industry. Okay, so for our today's sharing, we'd like to cover a number of topics. The first of all would be the tax audit trend, and the second one would be a few updates on new labor code 2019. And the next section will go through the COVID-19 labor issue and government response. What will be the reduction in a lot of kind of tax payment and contribution. And the last part, we wish to share with you some trend in tax trend, many notable official letters. Okay, and the very last part will be the question and answer section, so that you can share with us whatever question you have, or we're happy to address to it. Okay, the tax audit trend is the very first section that we wish to walk you through. Now, the very first thing is, the double taxation issue. So many of us say that individuals staying in Vietnam for less than 183 days, and then, their income is being paid by offshore organization, they are automatically entitled to tax exemption, and this is not the case, because there are a lot of conditions for individual to be qualified tax exemption. And for the first criteria of 183 days, every one of us know that it's very easy to monitor. But applying for a tax exemption, there's a lot more of the thing we need to consider, because there are other conditions here. We talk about the assessment of economic employer. So it doesn't have to be the company that paying income who consider as the economic employer. The domestic law introduced a lot of condition for the income. For the person who will be considered as the economic employer, and the condition here is that the economic employer must not be a resident of Vietnam. Now, the next task is the personal establishment task. So it depends on the operation of the company, of the economic employer they have in Vietnam, whether that economic employer have a permanent establishment in Vietnam And also, depending on the work that they perform in Vietnam, it could, constitute a PE, the permanent establishment of the economic employer. So this is a very complicated task, and we have support a lot of our client in, running this task prior to the preparation of the tax exemption application itself. Now, it is very important that we do this task before we actually kick off the process with the preparation of the documentation itself, because the process of applying documentation is not cost-free, because there are a lot of documentation which is required from, the home country tax authority to be issued. It takes a lot of time for the home country tax authority to respond to our requests. And, we need to also work with the service provider, the professional firm to support us with that process. All we handle itself is also very costly and time consuming. Not to mention that if, let's say, it takes too long to prepare and, we delay the process of paying tax payment, we need to face the consequence of paying penalty on a late settlement and late filing of tax liability. So the assessment of whether we are able to qualify for tax exemption is very important, and it should be done at the very first stage, before or right at the time the person comes to Vietnam. So we do support our client with the filing itself, and also to run the assessment at the start of the assignment, or even before that. And the filing timeline to file the tax exemption application is 15 days before the person actually, start to work in Vietnam. But in reality, we have successfully support a lot of our clients in back filing of tax exemption, and there's been a lot of success in that. So if you have any concern in, applying tax treaty relief, please do not hesitate to contact us. Okay. Now, the next concept is worldwide income declaration. So all of us know that, resident taxpayer is obliged to declare tax to the extent of their worldwide income, but not much of us know, how heavy the burden is, because some believe that, when the income is being paid from overseas by the offshore entity overseas, so such income is not required to be reported for Vietnam. Actually, this opinion is not correct, because for resident taxpayer, they need to declare every income. It's just not employment income, and also non-employment income for Vietnam tax purpose. And there is a trend that at the time of tax audit, then the authority would ask a lot of question, and that also including the information on a home country tax return, because based on this documentation, they will be able to see a lot of income, and there'll be cases individual don't declare the income that they paid to the bank account overseas, that will be revealed. And in a case that individual taxpayer refuse to coordinate with the tax authority, they won't easily give up. They would actively contact the home country tax authority to ask for the information. We need to be extra care that whenever we have the case where, particularly expat case where end up being resident taxpayer, there might be the time that we receive such a request of providing home country tax return. Okay. Now, moves to the another sharing is when it comes to short-term visit traveler, end up, having long-term assignment in Vietnam subsequently. Now we talk about the huge, the issue of a huge cost unwanted. We never wanted to be, arise due to the assessment of tax residency. Now, many of us know that an individual is considered as resident taxpayer if that individual is staying in Vietnam for 183 days in Vietnam for during the period of that concerned calendar year, or 12 consecutive months. All right, so that's the concept under the law. But not many of us know how to, when should we start to do the day count? So the law regulates that, we should start to do the day count right from the time the individual come to Vietnam, regardless whether that is for long-term assignment purpose or short-term, short-term visit purpose, either for work or for personal reasons. So it has to be counted from the first month they start coming to Vietnam. Now let's say Mr. A, he has some visit trip to Vietnam in January, and his long-term assignment for 2 years only start from May. Okay, so we need to count how many days he stay in Vietnam in a year 2020. Let's say he start coming to Vietnam in 2020. Now we need to count how many days the person stay in Vietnam in a year 2020 starting from January. So he actually start the work in May. Let's say he also have the work permit in May, but we have to report his worldwide income starting from January. In the case that in the year 2020, he stayed in Vietnam for more than 183 days. Now, the issue of this is that the pre-assignment income covering the period from January until end of April, which he has already paid tax in the other country, which is, it might have been a home country. Okay, that income is also need to be reported for Vietnam tax. That the issue of double taxation will arise. So we also help our client a lot in assessing what would be the way that we can reduce the impact of double taxation when it comes to that specific circumstance. But the thing we wish to highlight in our sharing today is that we need to be extra careful when we offer any long-term assignment to expatriate who already have some visit to Vietnam at the beginning of the year. We need to do the projection of number of days the person stay in Vietnam beforehand to avoid the unwanted costs of the huge tax liability to be end up that we are hardly able to deal with. Okay. Now, for talking about tax audit, dependent relief is also one of the areas that often receive a lot of attention here, because there are often the company face issue of data storage or data management system that they are not being able to pull out sufficient document at a time of audit, because for audit they only have 5 working days. It may not be consecutive days, but at the time they come to us, they ask for documentation, we will not be able to pull out, then we are in trouble. Okay, so this is the issue. We have supported a lot of our client, and we experience that they have faced a lot of issue like no dependent registration forms, or lacking of supporting documents, and then eligible dependent now no longer qualified dependent because they are beyond the 18 years old, especially for children. Okay, so those are the issues that commonly rise. The other issue that much harder for the company to manage is that dependent, they have the same personal ID number with the other taxpayer. Okay, or dependent that previously have income now no longer earn income, or dependent have previously issue with a tax code and how to deal with that. Okay, so our suggestion to the company is that the company should have review regularly, periodically, the document store, the data storage system, and also particularly the dependent matter itself. So it should be regularly reviewed to see, okay, whether we have supporting documents sufficiently or not. If not, then we have to fix it immediately before the time the tax authority come to us and do an audit. Okay, all right. And another thing that we wish to share is that it is a lot harder for dependent who's in indirect relationship with a taxpayer to be qualified eligible dependent. Now we talk about the individual like uncle and auntie, because recently in this year 2020, there has been a lot of official letter issued from the General Department of Taxation to relevant provincial tax authority, and from the tax authority themselves to specific taxpayer, giving guidance that okay, for the auntie and for auntie and uncle, the condition for them to be qualified eligible dependent is they need not to have any spouse, any children or brother and sister having the ability to bring up and take care of them, only in that circumstance it can be considered eligible dependent. So normally what we did in the past is that we obtain the letter of certification from the police department saying that, okay, we have a direct nurturing relationship for that particular person. Therefore, that person is our eligible dependent. Now that document is no longer sufficient. We need to obtain much more documentation to prove it. What are the specific documentation is not clearly mentioned under the law, but in case that we are not able to prove that there is no other person like spouse, children, and brother and sister have the ability to take care of them, then it is not qualified dependent. So we need to be extra care of this. And at the time you think is necessary, we need to throw a special project to review dependent registration in our organization to avoid a lot of penalty to be charged at the time the tax authority come to us. Now, talking about the very interesting topic as well, which is the new Labor Code 2019. It is going to take effect very soon in January 2021. Now, again, you can see that the development of labor law has been established in the year 1994, and then it's changed again in 2006. And then the current one is the Labor Code 2012 that we continue to be to use it until end of December this year. Now, the most important thing that to mention here is that for all of the agreements, the labor contracts and collective labor agreements, also internet labor rule that has been set up before the time the new Labor Code 2019 takes effect, which provide more favorable rights and conditions to the employee that remain to be effective unless it is otherwise, unless it is agreed otherwise in written. Okay, now in this new labor law is also introduced a new concept of income payer and worker do not establish a relationship of employment. So we say that, okay, there is no employment relationship on some particular cases whereby the income payer and the worker do not, the income payer do not supervise the work performance and also the time of the worker. So in this case, they do not form an employment relationship. Now, why is it so important? Because forming an employment relationship, it would expose to the income payer to a lot of the binding obligation. They need to ensure, labor safety standard for the person. They need to pay the person overtime in case that they work for more than 8 hours per day. They also need to, if they may need to contribute for social insurance for the person, and they may not be able to, cease the contract with a person whenever they want to. Okay, so there are a lot more, binding obligation on employers. So, in order to be open, give more flexibility for the business to operate, the new law has introduced this concept, and also. The law is introduced another concept whereby, in case of the agreement, we deliberately describe it as the other type, not the labor contract. However, this contract is still carrying the nature of the labor contract. It's still considered as a valid labor contract. In the case that there are 3 criteria we meet. The 3 criteria to be met in order for a contract to consider a labor contract is that we have a job, we're getting paid, and most importantly is that the person is working under the supervision of the employer or the income payer. So in any case that 3 criteria is identified, that contract is considered a labor contract, and that gives all of a binding obligation on the income payer being the employer. Okay. All right. Now, talk about the trade union. All of us know that okay, we have to contribute for trade union, regardless whether we have a trade union or not to have a trade union. Now, talking about the purpose of having a trade union is to protect the employee right. The new law recognizes it, and it has introduced another, concept whereby it gives more right and more ability for employee to express their voice and their interest, their right. By establishing internal employee organization is exactly the same function with a trade union. But on top of the trade union, the company can have more internal employee organization so that they can express their voice. Okay, in order for this organization to be recognized by law, it needs to be registered with a relevant authority. But this is open to the opportunity whereby, company who doesn't want to establish a trade union, because once we establish trade union, definitely our employee have to contribute to it. Okay, for some company who don't want to establish trade union because we don't want to contribute, then we can establish internal employee organization for, the playground for them to express their voice and opinion. Okay, so company can have both trade union and internal employee organization. They can have a single trade union or internal employee organization, or they can have nothing at all. Okay. Now, the law also introduced a concept whereby the current law, the law 2012 doesn't have it, is the concept of apprenticeship and on-the-job training. Now, apprenticeship here is, the person who we recruit and trained at our workplace, okay, and that referred to internship. So that the law also specified very clearly that there is no time limit for apprenticeship or internship. So we can have it, the extension of the time can be multiple, and we can sign many contracts relating to apprenticeship or internship. Unlike the apprenticeship, for on-the-job training is also the new concept. Okay, for on-the-job training, the maximum time is only 3 months. So I think that it will be less likely used. The only difference between this is that apprenticeship is trained by us, and on-the-job training, we only instructed them to limitedly to perform the work, and then it must not exceed 3 months, unlike apprenticeship. Okay. Now, we have a new concept under the law that previously, only contract in writing is considered as legal, and it has, and that will be recognized under the law. Now, the law also recognizes the labor e-contract. This is the contract in the form of data message in accordance with the law on electronic transaction, which are valid and written similar, which has similar value with written labor contract. Now, the use of labor e-contract is not being clearly regulated because this is a new law, and we believe that there's the degree and circular to be issued to complete what would be how do we able to see whether an e-contract is valid and is completed. But so that we acknowledge the new type of contract. And we also believe that in order for labor e-contract to be valid, it needs to be signed by the individual electronic signature. But we are still waiting for the guidance on this. Now, for verbal contract is also recognized under the new law. And for the verbal contract, the maximum length of it is only less than 1 month. And for labor contract, there would not be any probation. Now, for the contract that must be in writing, for the other contract, except for the one that mentioning here, it can be carried the form of e-contract or verbal contract. But there are certain contracts that must be made in writing, in which the contract that for seasonal works or specific terms less than 12 months, then we need to be made in writing. Or the labor contract that we sign with individual less than 15 years old, and it needs to be put in writing as well. And for labor contract with domestic worker, which is the household helper, then it needs to be put in writing. Okay, for the other case, like I've just said, e-contract and verbal contract may apply. Now, every one of us know in the past, in a current law, the law 2012, it recognized three kinds of contract: the seasonal, seasonal contract less than 12 months, the definite contract for the term is from 12 to 36 months, and indefinite contract. Okay, so those are three kinds of contract in the current law. Now, the new law has removed seasonal contract, and now is only recognized two kinds of contract: with the contract with definite term and a contract with indefinite term. So definite term cover any kind of contract with more than from a month and above. Okay, and the reason why there is such a remover is because it has created a lot of difficulties on enterprise to apply, to how they apply correctly the concept of seasonal contract when there is a need for enterprise to offer contract less than 12 months, but the nature of that is regular basis for individual because they don't have a need to offer a job for them for more than 12 months. However, the nature of seasonal contract is for job who has a nature of irregular and temporary basis. So in case that they offer a regular job to a person who less than 12 months, they may be identified in a situation of violating the law, because for order of a job that is regular basis, it needs to be more than 12 months. So recognizing this, the law has changed. And now the concept of seasonal contract, it's just, for the contract to be put in writing, there's no limitation on whether we offer regular job or irregular job. Now, in case that our contract expired, we need to make sure that we have it renewed or, must sign a new labor contract within 30 days, because if we don't do this, the contract will turn into indefinite contract. And also the validity of the labor contract will follow our work permit, and it would not be extended over 2 years. Okay. Now, again, in the new labor law, it doesn't allow us to put a next to our existing employment contract in order to extend the period of that. We need to sign a new annex or addendum. For the probation term can be mentioned in the labor contract itself. And for management level, the probation period can go up to 6 months, because, for management level, the cost of it is very high, and we often do not know whether the person gonna, perform the work good, because the work is complex and we need more time to test it. So the new law allows for management level, the probation period can go up to 6 months. And during probation period, any party can have the right to cancel the contract without notice or compensation. Okay. Now, compared with the new labor, the existing labor code, the Labor Code 2019 has added a number of cases whereby the employer is allowed to unilaterally terminate the labor contract. So this is a case whereby the employee reached retirement age, and very importantly, when employees are arbitrarily absent from work without proper reason from 5 consecutive days or more, then it is okay for the employer to cease the contract with them. And then when the employee give false information to the employer, the contract is also considered as invalid. Now, there are additional 10 cases whereby the labor contract would be automatically terminated. We are not able to list out all of the 10 cases, but there are 3 typical cases. whereby a foreign employee is, expelled from Vietnam, or a foreign employee working in Vietnam when the work permit expired, or when the person failed to meet the job requirement during probation period. So there are typical new case. Right, okay. The new law also introduced the concept of, some of the requirement on salary payment, whereby it allows salary in foreign currency to be paid when it comes to foreign employee, and the employer must provide payroll statement to our employee. And when the income payer or the employer pay salary, they need to pay the bank account transfer fee as well. And when a person unable to receive the salary, they can outright another person to do it. And the employer must not restrict or to interfere with the employee right how to use their money, or to force employee to purchase the good or service of the employer. The income can be paid, reward and bonus can be paid in any forms of, benefits in kind, right? It doesn't have to be money all the time. And the government does not directly intervene in enterprise salary, salary scale building, or in the process they make payroll payments or determination of labor norm, etc. Okay, and importantly, that the employer must pay for work suspension, especially in a time of COVID. Okay. And the salary to be agreed will follow two-party, negotiation and agreement, but it must not less than the minimum regional wage. Okay, the rest time. Now, rest time of the employee is now being added to ensure that individual having more benefit. In case the person work consecutively for 6 hours, then they would be able to give a rest break of 30 minutes and they will get paid for that break time. Now, nighttime work with 45-minute break would be given. 45 minutes consecutively would be given, and the time that they have break, nighttime break would not be a paid time. Okay, so the employees also, the employee who work for 6 hours or more in a day can entitle to 30-minute rest, and this is non-paid. Okay. Personal leave would also extend to cover the case whereby their adoptive father and mother pass away. The working time, now, the minimum of 30 hours per month for overtime is reduced. Is removed, and then will be replaced by 40 hours per month, but it should not exceed 300 hours per year. Now, talking about retirement age. For male, starting from January 21, the retirement age for male has been increased to 60 years and 3 months. In each of the year, it will be increased by another 3 months. And for female employee, it is 55 and 4 months, and each of the year it will be increased by another 4 months. Okay, now, under the new labor law, it also allowed the employer to sign contract with elderly employee multiple times. And for employer, they need to build labor usage plan, and they need to consult employee on the labor usage plan, and publicly notify 15 days from the date of adoption. Periodically, dialogue is a new concept to be introduced under the new law, whereby it supplements the number of circumstances requiring the periodical dialogue. Okay, I have here the list of what would be the case. Okay. In a case whereby one or more employee regularly fail to meet the performance requirement, or in a case that the organization is going through restructure, for the reason of economic downturn or application of new technology, or when they build labor usage plan, or when they build the bonus policy, salary scale, internal labor rule, they need to consult the employee. And especially when they, in the event of suspension of employee work, they need to hold periodical dialogue with, their employee as a whole, or a group of employee representative, or personal dialogue with the person themselves. Okay. Expand the scope of collective labor agreement, whereby it allows many enterprises to engage with one collective labor agreement. It brings more opportunity to the employee to assess more favorable requirements. Okay, for public holiday and annual leave, it will be added one more day to National Independence Day on 1/3 of September. So we normally have 2nd of December to be the national day off. So we will have one more day. And for annual leave of employee, for every 5 years of employment, it will be added one more day. Now, for internal labor regulation, every enterprise needs to have internal labor regulation, and for enterprise who have more than 10 employees would need to have internal labor regulation in writing. The new law is also introduced, more right and benefits to female employee, in a way that for female employee who is being pregnant or raising children under 12 years old, they would have, they will be given the priority to sign a new contract when their labor contract expires. So this is a new thing. And also another protection to, female employees, that they can have the right to terminate the contract with the company legally and ensure that they got all of the benefit in accordance with the labor contract, and also other agreement with the company, and then their final pay is getting protected. As at the time, they feel they have the advice from a doctor that it is not safe for them to carrying the work, and is not safe for the baby. And what certificate we're talking about here is the confirmation from competent medical facility and continuing the work that would adversely impact the well-being of the baby. And so the person can stop the work, and also entitled to all of the pay as agreed. Okay, so it is also another safeguard on employer that who want to fire a pregnant individual so that they would need to make sure that such certificate is available in order for them to safely say goodbye to the person. Okay, COVID-19 labor issue and government response. So there are certain benefit, give back that the government allowed to offer to enterprise in order to support them in the difficult time of COVID-19. The first thing that we talk about is a deferral of value-added tax and personal income tax for specific organization up to 12 months. Okay. So for some enterprise working in the industry of agriculture, construction, transportation, storage, tourism, artistry, banking, small and medium enterprise, those in this sector allowed to have VAT and PAT costs being deferred up to 12 months. Okay. And payments of suspension wage is required on employer who's temporarily stopped working because of medical quarantine, but they need to pay suspension wage. And as I earlier mentioned, it must not be less than the minimum wage. Now, the deadline for trade union payment is also deferred up to 12 months, from 6 months up to 12 months, in the case that the employee has lost 15% of their employee due to COVID-19. And for the contribution of, pension fund and death benefit, it can be suspended up to 12 months, but the condition is much tough as compared with that for trade union deferral payment. Is those in the enterprise need to be, their business operation need to be suspended for at least 1 month, or they have really difficulties in from the COVID-19, particularly if that is that they lost 50% of their 50% of their employee, and they also lost 50% of their total assets. And for the social insurance premium payment, they must sufficiently pay, or they need to pay and have everything settled up until end of January 2019. So with that condition satisfied, then they can have, suspension, no longer have to pay at all for the next 12 months. Now, this is for this fund, pension fund and death benefit, it is a lot because, for all of our social insurance payment, both employer and employee have to pay from 34 to 35%. Now, this for this fund, it comprises about 22% already. 14% is employer pay, 8% employee to pay. So it gives a lot of tax saving. So if any of our organization identified in this circumstance, or if we are aware of any organization fall into this circumstance, it gives a lot of cost saving. All right. Now, another positive change is that there will be more deduction that we can apply to our pay. Previously, for personal deduction is only 9 million per month, but now it has been increased from 11 million per month starting July this year. And for each of the eligible dependent, we can take the deduction level of 4.4 million starting July instead of 3.6 million as before. Now, it will be applied for the year 2019 tax. 2020 tax return and not applicable for the year 2019. And at the time that we do annual return for the year 2020, we will throw back. We'll take the true up calculation and, apply retrospectively the new rate for the period from January. Now, another opportunity for us to reduce the fund contribution when it comes to occupational accident and disease benefit fund. Now, the normal rate that we need to pay is 0.5%. We can have it reduced to 0.3%, but there are a lot of conditions to follow. The first condition is that we need not to pay any penalty at all when it comes to administrative violation of social insurance, and we need to submit periodically the report on workplace accident, and we need not to have, we must ensure that we have the rate of occupational accident and disease being reduced as compared to the preceding year by 15%. Okay, and that's not all. It's not automatically applied. We need to submit the application to the Ministry of Labor Law and have their agreement to apply it for the duration of 36 months. Okay, now we are at the notable official letter, the tax trend. Okay, very good things that we wish to update firstly with you before we move to the other update is that for visa and temporary resident card, previously there has been a lot of official letters being issued years in the past saying that this is a taxable benefit of the individual. Now, the General Department of Taxation has confirmed that for visa and temporary resident card, if it is paid by the employer for the purpose of taking the person coming to Vietnam to start a work here or for business trip purpose, then it should not be considered as a taxable income of the individual. However, in case that the visa and the temporary resident card paid by the employer for personal purpose of the person itself, so it will be considered as taxable income. So that, provide. This is a very positive change, and applying this can result in a lot of cost saving for the organization. And it's also more reasonable change that as compared with what has been, regulated and guided by the authority in the past, that everything is taxable. Now, bonus in stock. Okay, so individual having bonus in the form of stock is also need to pay tax. And most importantly is that not just employment income that we talk about here, is also non-employment income that they need to declare. For employment income, it would be the value which is recorded in the book of account at the time the person transferred the share and receives the cash payment. And for capital transfer income, that will be the value of the transaction itself. Okay. Now, what should we do at the time we do the final pay to the person? What will be the applicable tax rate applied? So this official letter is also giving guidance on what should we do, what tax rate should we apply at the time that we make the final payment for the persons. Okay, so for the salary, wages, and any other income that is paid within the time that the person, within the time that the person worked for us, within the time that the contract is still valid, it should be withheld at progressive tax rate. And any subsequent income that is paid after the contract validity date, which is a time that it's expired already, 10% tax rate would be applicable, except when that income is non-taxable, which is, for example, like severance allowance. Okay, for non-resident, the tax rate is not 10%, it's 20%. Now, for voucher and gift that we often offer to our employee, when the company purchase a gift voucher from the other organization, for example, like supermarket, they need to withhold the tax, and the value of that would be based on the gift value in the voucher. So that is considered as a taxable income for our employee. Okay, and when the company offer gift in kind to employees through lucky draw programs, previously those income in many official letters in the past year, they perceive that, this is not kind of gift that need registration, and therefore this gift is not considered as taxable income of the employee. Now it's no longer the case. Now the law the tax change. And in many ruling recently issued by the tax authority has reconfirmed and confirmed again that this is considered as employment income and subject to personal income tax withholding when we give gift to our employee through lucky draw. In case of we make any payment to individual being our agents for business support purpose, then the withholding rate is only 1%. All right. Okay, so this has come to the end of our today's sharing, and we continue with another very interesting topic of question and answer.
Well, thank you very much, Ms. Ngoc, for the comprehensive sharing. And I think some of the good news that we heard that like we have additional public holidays, and also next time if you don't win anything in the lucky draw, it might be a good thing. You don't need to pay any PIT.
Yeah.
Right. Let's look at some of the questions. Ms. Ngoc, do you want to address some of that?
Yeah, I'm happy to, Brian.
Right. One of the questions saying that how to prove that the benefit of visa and the TRC is the employer obligations.
Okay. Yeah. There's not any specific part under the law which regulate how do we know that it is for, the obligation of the employer. So that would be based on the interpretation of the tax authority at the time they come to us, and we will have to put our logic into what we say and then convince them. But and because our law depends entirely on the documentation maintenance, so In case that in our policy, we mentioned very clear that it is our obligation to pay for visa and temporary resident card for individual coming to Vietnam to work, or whenever our employee have business trip overseas, then we have to pay for such costs. And it also mentioned in the labor contract that these is entirely the obligation of the employer rather than the employee to ensure to enable the person perform the work here. So with that, all of the documentation maintenance, then we can argue that this is the obligation of the employer rather than the benefit of the employee.
Great. I mean, it should totally document it in the contract of the employee. And now another interesting question is about like the reward from the trade union fund to the employee. Do they have to file PIT on that?
The reward from the trade union, I don't think so, because no, because that is something after tax. But can we be more specific in knowing, what sort of reward are we talking about?
Let's say some of the yearly bonuses or some of the lucky draws.
But that is paid by the trade union or
trade union fund to from the trade union fund. Yeah.
Okay. No, I don't think it's tax. I don't think that this is taxable income.
While we are waiting for other questions, and I think we still have like 5 minutes. So do you mind to share about like in these current situations like the COVID-19 and touch on a bit on the immigrations part, like how we can get the informations, like when the foreigner can come in, what should the company do to get their staff, their foreign staff back to Vietnam to work. There's a follow-up questions that why do you think that the lucky draw from the tax union fund is non-taxable?
Okay, because actually we have to contribute for that fund, right? The employer and the employee have already contributed for that fund. And then we take back the benefit from what we contribute. It should not be taxable.
And one final question. What is the tax treatment to the foreigner who are under 183 days in Vietnam because of COVID-19? I presume that they are still working for the Vietnam company while they are overseas.
All right, that is a very interesting question. Yeah. We have been receiving a lot of similar questions from our client because that is not something unusual, especially during the COVID time like this. So we understand that many individuals cannot come to Vietnam, although that they remain a role with Vietnam company. So they keep on, they currently performing the work remotely from overseas. So with that working arrangement, the question is that, do they have to pay tax in Vietnam? I wish I can say no, but the law say very clearly that individual who, never come to Vietnam at all would be regarded as non-resident of Vietnam, and they would have to pay tax to the extent of the income which is sourcing in Vietnam. Now, the definition of income sourcing in Vietnam, in the case that, for non-resident taxpayer, is also regulated under the law. For individual coming to Vietnam, it will be based on the day that they spend the work in Vietnam. For individual who does not come to Vietnam, so the time that they perform the work remotely for Vietnam will be considered as the basis to apportion the income for Vietnam tax purpose.
Well, it sounds really like complicated calculations on that, right?
It will be a very complicated. You're right, Brian. But we support our client this analysis, and we can help the client to advise, how much income is being exposed for Vietnam tax purpose, and what would be the alternative in case that the company really concerned on a cost issue. Then we do give a lot of advice to our client in that particular circumstance and how to avoid double taxation.
We have now one final minute, why don't you tell the audience what kind of services that you have to help them in terms of the PIT or their immigrations?
All right. So the first thing I initially introduced, we do support our client in compliant, like payroll compliance and tax filing compliance. And recently, we have been supporting our client a lot in advisory projects, in advising on, remuneration restructuring, or how they could reduce the tax cost burden in order to, especially that would be, commonly we receive a lot of question and ask for help from company, because cost saving is becoming very important nowadays. Okay, so we can do, tax health check review. We can review many matters, including dependent, including business trip expenses, because that would be the area that exposed to risk. Okay, so that comes to tax health check review. That would be the very necessary preparation for company to take up before the time that they have tax audit from the tax authority. Okay, so we can have a lot of other ad hoc projects, like preparing a company policy, and especially amendment of relevant policy, because of with the introduction of the new labor law, we have been receiving a lot of requests from our existing client as well as other potential client in revising policy, because it is a must to have the policy revised to include all of the terms in the new labor law. Otherwise, their internal policy would be outdated and therefore considered to be invalid or violation of the law. So we have been receiving a lot of requests lately, not to wait until 1st January 2021, because the company they want the company they want to have sufficient time to have their policy review as well. So they want to make the move as early as they can to have their policy amended and considered to be valid when the time comes.
Right, great. So thank you very much for your participations and questions. And for more information, or if you need our help, please contact our beautiful and talented Miss Ngoc and her team. And once again, thank you very much for joining our webinar today. We look forward to receiving you at our coming webinars. Thank you.
Thank you. Have a great day. Take a very good care of yourself. Thank you. Bye-bye.